A will is a document in which you, the testator, get to decide who receives your assets after you pass. So in your will, you can name an executor. That's the person who's going to be responsible for carrying out the language of your will in the event you should pass away. So only certain assets will pass under your will in Iowa, and I think there's a pretty common misconception that if I have a will, that's all I need to do in my estate plan, but that's not necessarily the case. If you have property that's, say, jointly owned or has a named beneficiary, those assets are not going to pass under your will. Instead, they'll pass to the surviving joint owner or to the named beneficiary, regardless of what your will says. So say, for example, I'm unmarried and I have a will that leaves all my property to charity. And at the time of my passing, I have a home that I own jointly with my daughter, a $100,000 retirement account, and I have my brother named as beneficiary, and then I've got a $50,000 bank account with no joint owners, no beneficiaries, and I die. Well, my daughter is going to receive the home because she's the surviving joint owner. My brother is going to receive my $100,000 retirement account because he's the named beneficiary. So we don't care what the will says. We know that the home and the account goes straight to my siblings because they're named on those assets. For the $50,000 bank account, we don't have a named beneficiary, we don't have a joint owner, so then we look to the language of the will to see what happens to that asset, and oh, the will says everything goes to charity. So that means that in that scenario, the charity would receive only the $50,000. So it's important to talk with your lawyer about how your will fit in with the rest of your estate plan, meaning your beneficiary designations, your form of ownership of your different assets, and other aspects that your lawyer can visit with you about. It's important to have a will because if you die without a will in Iowa, then Iowa law is forced to step in and decide how you probably would have wanted your assets to pass. So there's a set of laws called the Intestacy Laws, and intestacy just means you die without a will. And those laws tell us who receives assets after a person passes without a will. It's generally your closest living relatives, but that might not always be what you want to have happen. So it's important to sign a will and properly execute it as required by law in order to make sure that your assets pass the way you want. Your will should always be signed in front of 2 witnesses who also need to sign. You must tell the witnesses that this is your will. And you need to have legal capacity to sign the will. And there are certain other very rigid and strict formalities that have to be carried out in order for your will to take effect in Iowa. So make sure you're working with an attorney who can guide you and help you sign your will to make sure that it will be effective. A will doesn't take effect until it's been admitted to probate, and probate happens after a person passes. The probate process is a court process that involves the probate judge, and the probate judge oversees your executor as your executor pays any debts, pays any taxes and creditors, and then distributes the rest of your property as you've provided in your will. A lot of folks can find that it's overwhelming to start collecting the information they need to prepare a will and start thinking about who they want to name as their executor and who they want to name as their beneficiaries. To help you get started with that, the Food Bank of Iowa has a free, easy-to-use guide for making a will, and we'll put a link to that on your screen.